Okay, so let's talk about 2104 first, the residential purchase agreement. First of all, I would like to say that I have reduced it from 16 pages to 15 pages. Yeah. I'm always hearing about it when it gets longer, guys, so when it gets shorter, I want to hear about it too. All right, I got to get the applause for that because that was, and we didn't take out anything important. I just kind of reworded things and made things more concise without changing the meaning of anything. So we're not sacrificing anything. Okay, so paragraph 3 and 4, the off-market and time off-market fee. So that used to be combined into one paragraph. But, you know, even if you don't use the TOM fee, the property is off the market, right? And all you can accept is backup contracts on the property once you go under contract. And the only exception to that, of course, is the buyer sale contingency. And the buyer sale contingency allows the seller to keep the property in active status until such time as the buyer notifies the seller that their property has gone under contract. Now, different MLSs handle that differently, right? Some of you guys, you have different status for that buyer sale contingency and how you can market it. And all marketing of the property is subject to whatever the MLS rules are in your area, okay? And we can talk about that in just a second because I do have that some language that we added on that. But we do have now 2 different paragraphs for that. So we have paragraph 3, which is off the market, explaining that the property is off the market once you go under contract, except for backup contracts. And of course, that's unless otherwise provided in an amendment, and the buyer sale contingency is an amendment, right? So if that says something differently, then that would apply. And it explains what off the market is, because when we were creating the TOM fee, there was a lot of discussion about what does it mean to be off the market, and it means that the seller can't accept any other contracts on the property except for backup contracts. And we do say in that paragraph, which came out of the meeting on Tuesday, that all of that marketing is subject to MLS rules. So in the event that your MLS has a status that allows you to keep it in active status, because that's what the buyer sale contingency, for example, says you can do, then you can do that. But if they require you to put it in pending status, then that's what you have to do. So there's language in that paragraph that specifically explains that all the marketing of the property is subject to MLS rules. If the property is in the MLS, which most of the properties going forward under clear cooperation, for those of you who were yesterday, are going to be in the MLS. So those have been divided into 2 paragraphs. I don't want to go down this rabbit hole because we could be here all day talking about TOM, right? But just curious, is anybody using it? A few people are using it, okay. So, you know, it's interesting. Somebody said to me yesterday about the TOM fee, they said we should put it on an addendum because then the seller can counter. And I said, well, first of all, I think that the concern of the Forms Committee, and my concern would be that it would never get used at all if it was on an addendum. But the other point that I made was the fact that this is not just a seller thing, guys. I cannot tell you the number of phone calls I get on the hotline where the seller is not releasing earnest money in a situation where they should be releasing earnest money. And no matter how clear we make it in the contract, the buyer's entitled to a refund of the earnest money if they can't come to resolution on the objections, or they just decide to terminate and not even ask the seller to cure anything. No matter how clear we make that, you can't force anybody to do anything, right? You can't force sellers to sign that distribution form. And we all know that title companies aren't releasing those funds without a distribution form, right? So when they call me and they tell me the seller's being unreasonable and not doing what the seller's supposed to be doing under the contract, I find that a perfect opportunity after we've kind of gone through the scenario and I give them their options to talk about the TOM fee. Because if I'm a buyer, I'm going to be writing TOM fee money all day long until I get past inspections. If I can write $150, $250 check, be able to kick the tires, look under the hood, decide if I want to buy the house, and if I don't, walk away without asking the seller to do anything for me at that point, then I'm going to be signing up for that all day long and twice on Tuesday, right? So you guys, it's not just a seller thing, and I think it's important you guys are able to talk to your clients about that option. Because and I've told you this before, if you guys get into a situation with a buyer and seller where the seller's refusing to distribute earnest money, and the buyer's having to go through mediation and maybe even litigation to deal with that, and they find out there was an alternative, they find out there was an option for them to pay a TOM fee perhaps and not have to deal with any of that, they're going to be looking at you wondering why you didn't have that conversation with them. okay? And I know those conversations are a little hard to have, which is why I created an information sheet on the TOM fee, and it talks all about benefits to buyers, benefits to sellers. Because on the seller side of it, no matter how small the TOM fee is, what happens if the buyer wants to walk away at the end of inspections and they do everything timely? What does the seller get? They get a TOM fee if they got a TOM fee, but if they don't get a TOM fee, what do they get? They get nada. They get nothing, right? They don't get to take their family to dinner at Red Lobster. They don't get anything. All right? So at least if you got a TOM fee, they got a little something. So, it's a conversation you guys need to be having. And I know it's going to take a long time before we see whether or not that TOM fee actually does what it was intended to do, which is mitigate earnest money disputes. It's going to require people using it, and it's going to require some time. So that's enough on time for today, since that's not what we're here to talk about. In the fixture section, which is paragraph 6D, and some of the paragraphs have been renumbered, so all of you guys who just studied these forms and know all these paragraph numbers, now some of them are off. So I'm sorry about that, Beverly. So Beverly's shaking her head. She knows every paragraph in the first agreement. Now I've screwed that up, so I'm sorry. So paragraph 6D is your fixtures paragraph, and there are a few things that we've added under the fixtures to clarify. So under the window coverings, we say not including curtains unless otherwise indicated. Now, also in that, what's important to note in the fixture section, you guys, at the end of the day, those lists are not all inclusive, right? There's a bunch of fixtures and a bunch of personal property that we don't list in our purchase agreement, and I can assure you it would be a lot longer than 16 pages if we tried to list everything as a fixture and everything as a personal property. So at the end of the day, if it's not specifically provided for in one of those paragraphs, you have to go back to the definition of fixture and personal property, right? If you're questioning, is it a fixture, does it stay or does it go, and it's not specifically listed, you have to go back to the definitions that we created. And the definitions are at the back of the purchase agreement. Nobody ever wants to look at those until they're important, right? And then they're important when they're important. So you guys first and foremost need to remember that about the fixture and personal property section. But we do have, for example, window coverings, attached window coverings in the fixture section, and then we have other type of window coverings in the personal property section. And the idea, again, the differentiation, if you look at the definitions of those, is that attached window coverings are what? They're attached. Things that are attached to the wall. And we define in the fixture section now, we actually added some language in the fixture section that defines things, what does it mean to be affixed to the property? Because everybody thinks, well, it's a fix, but I can take it off, a little spackle, you'll never know that I took that off the wall, right? No one's gonna know, right, yeah. Any kind of repair that has to be done as a result of you taking it is a fixture, guys. And that's how we define fixtures. We actually added some language to say that, okay? So anytime, we know all repairs can be, all damage can be repaired. But no matter how small the damage, if you have to repair something, when you remove it from the real property, then it becomes a fixture. That's how we define them. So, but we did clarify in the fixture section that when we're talking about attached window coverings, we're not talking about curtains that can be taken off the rods. Okay, that's covered in the personal property section. If those are going to stay, those need to be marked in the personal property section. Under Murphy beds, we added language including the mattress. Oh, there's a reason for everything, right? Murphy's beds are in there for a reason, aren't they, Kay? Yeah, so I know that we could go on and on with all of your horror stories about things people try to take, right? And so again, that list could be absolutely crazy. But we do try to cover some of these things, and yes, we're saying that the mattress has to stay. Under TV wall mounts, under the fixture section, we said they're not including the TVs. Okay, so the mount is actually attached to the wall, right? If you remove that, you're going to have damage to the property that you're going to have to repair. The TVs attached to the wall mounts can be removed without causing any damage to the real property. So we've clarified that. You guys, this next thing in personal property is very important because this comes up all the time. And I don't need a show of hands to know how many of you have bought, I don't know, all sorts of things, washers and dryers and, all sorts of personal property because you're relying on what was in the MLS. The MLS said this was going to stay. The MLS said that was going to stay. The MLS said that, the sales price was such and such, and you're probably not going to be selling the house for such and such, right? Because there's negotiations involved. So maybe they were going to leave all those things if there was a full price offer, but they're not getting a full price offer, and so they're taking their washer and dryer with them now, right? So you guys cannot rely on the MLS listing unless you incorporate the MLS listing and I know what you're going to say about that, Sandy Lee, into the purchase contract. I'm not advocating or not advocating for that. I'm just explaining to you that the only way to pull those elements in is to reference the MLS and attach it as an exhibit. Yeah, so Sandy Lee does not like the idea of incorporating the whole MLS into the purchase agreement, and I'm, again, not suggesting you do that, but what I am telling you is that just because it's in there doesn't mean it's part of the purchase agreement unless you guys have made it part of the purchase agreement, all right? So I'm telling you, I get that call all the time. Brokers are always having to buy washers and dryers and refrigerators and all sorts of items that they neglected to put in that section of the personal property section, and they're relying on the fact that it was in the MLS. So your takeaway from today, if nothing else, is that, okay? And we do have language now in the personal property section that addresses that. In the finance or cash purchase section, we have an important notice. Yeah, so sellers, telling the sellers, the brokers involved in the transaction are not responsible for making sure that those are real proof of fund letters, real cash pre-qual letters. They're not responsible for confirming, verifying the veracity, legitimacy of those letters, okay? Everything comes from somewhere, right, guys? Yep. Claim down in Albuquerque, a buyer presented a bad proof of funds letter. And it got passed along from the buyer broker to the listing broker who gave it to the seller. And when the buyer flaked out because they really didn't have the money and terminated the contract the day before closing, and they had no money, again, they were looking at the brokers who provided them the letter saying, you know, it's your responsibility to make sure this was a real letter and they really had these funds available. And so we are telling the seller that that is absolutely not the case. It's really important for you guys, listing brokers, when you're working with your sellers, to explain, if you feel uncomfortable with the letter, then, you know, do what you got to do to feel comfortable with the letter. But that's not my responsibility or the buyer broker's responsibility. Of course, if you know that it's fraudulent, that's not okay, right? You can't pass along a fraudulent letter, right? And everybody knows that. But there's certainly a big difference between that and passing a letter along with no knowledge and then somehow being responsible for the fact that the funds aren't available or the pre-call letter was somehow, you know, forged. So that's in the heading now. Under paragraph 7, little 5, the language was modified slightly, and this has to do with the time frame for providing the written rejection letter from the lender in the event that the seller can't get financing. So we have a financing contingency in the contract, right? And that means that in the event that the buyer can't get financing, they're not in breach of the contract, right? Because they've got a financing contingency. And normally they would suffer no damages under a contingency provision, right? So if the appraisal doesn't come in, they get to walk away and they get the earnest money back. They don't get any, you know, the seller gets no damages whatsoever. We have a little kind of strange caveat in our purchase agreement for the financing if the buyer doesn't notify the seller timely that they're not getting their financing. And the reason for that is what? Well, we don't want the seller to load up the truck, right? And be driving out of the driveway and then just find out. And what was happening before we added this language is they were finding out actually after the closing date, right? They just wouldn't show up for closing, and then a couple days later, a few days later, you get a letter from the lender saying, oh, by the way, they can't close on the property, they can't get any money, right? And by that time, the seller has already packed up the truck and moved out. And so we added this language a number of years ago that they had to provide some notice before the closing date. Otherwise, they were going to lose their earnest money. No additional damages because, again, the contingency is still in place, right? But they were going to lose their earnest money. So that even though it is a contingency still, there is a possibility they can lose their earnest money if they don't notify timely. Now, the new language, which we cleared up a little bit, requires it 3 days before closing. And that's kind of tied to the closing disclosure statement that has to be provided 3 days before closing. So they're going to see that and they're going to figure out if financing is going to work or it's not going to work. You guys can change that number, right? So, of course, from a buyer's perspective, you want to, a lot of times, push that as close to closing as possible. If we can do it 11:59 the day before closing, that would be great, right? And that option is still available to you. But in the event that you're a seller, you're going to want that probably a few days before closing. You're going to want to know what's going on. So that has been modified a little bit to reflect this new way to approach this. I will make note about this, and this is covered in that paragraph, that as far as delivery is concerned, how do we define delivery in our purchase agreement? right? So how do we find deadlines in delivery? We count calendar days, right? We're counting calendar days. If it falls on a weekend or legal holiday, or a weekend or legal holiday, it rolls over to the next business day. So you're counting Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday. And if your deadline for performance, the final day for performance, falls on a weekend or legal holiday, you're rolling it over to the next business day. That's another thing that's in our definition section. Again, nobody cares about that stuff until they care about that stuff. And you won't believe the number of calls I get about that. Well, we don't count calendar days, weekends, right? When we're doing our calculations. If you guys know nothing else from our contract, know how to calculate deadlines, right? And how to count the days for the contract. So in this one particular paragraph, we do it a little bit differently. For purposes of this paragraph, we're not rolling it over. Did you guys hear me?
Yes. Not rolling it over.
Not rolling it over. It specifically says that. Because think about it. If we say that the deadline, let's say you're closing on Monday morning, and you have a deadline of 11:59 the day before closing, right? What would happen under our normal periods that we have in there? It's going to roll over, right? And then we're going to be after closing before you get that letter, right? So we don't want that to happen because the whole idea is getting the notice to the seller before closing. So we don't roll over for purposes of this paragraph and this paragraph only, guys. So make note of that. That's a very important point. And that's nothing new. That's always been the way this paragraph works. Because again, of that Monday, mostly because of that Monday closing. We don't want them rolling it over and saying, oh, well, I have 11:59, the day of closing at that night at 11:59 to provide the letter. No, day before is still good. So remember that that's the way that paragraph works. In paragraph 9b, the appraisal order date is gone. Are you guys the same people that were clapping when I said I put the appraisal date in at my last meeting? Yeah, okay. So I don't know if you guys remember, but a number of years ago, it actually was in there for about 3 weeks too. I understand in concept, it's a great idea, right? We want to make sure that the buyer is ordering that for a timely closing. We don't want them dragging their feet until they get through the inspections or whatever else they have to do before they order the appraisal, because we're concerned about that closing date. But you guys, it's being so drastically abused by sellers, right? You have to remember that we define a breach of our contract, any breach of our contract, as a material breach. And what's the relevancy of that? Well, the relevancy is that the courts will often look at a breach of a contract and make a determination as to whether or not it's a material breach or a non-material breach. Non-material breaches typically do not relieve the non-breaching party from further performance, okay? They're just little things, right? So it doesn't mean if I screw this up like this, that you get to not sell your house to me now, right? It's a little tiny breach. If it's a big breach, then yes, the other party no longer has to perform on the contract. We define in our contract, in an attempt to kind of take the subjectivity out of that whole thing, we define every breach as a material breach. We talk about time is of the essence, right? We say that anything you do not perform on this and the non-breaching party will generally be relieved from further performance, okay? So what was happening with this appraisal date is that sellers are getting backup offers, and it's so much prettier than the offer I have right now, right? And I would really love to take that backup contract, right? And I find out that the buyer missed ordering the appraisal by a day or 2 days, right? And is that going to create any issue for the seller in the way of closing? No, they're still going to close just like they were going to. Otherwise, they've suffered absolutely no damages as a result of this. But what were sellers doing? They were terminating contracts so that they could take the backup offer, right? It's also hard too, because sometimes that's not as easy information to get from the lender or from even the listing broker sometimes, so that the buyer's broker, so that the listing broker can kind of stay on top of that, because it's always important. Also, which I tell you guys all the time, is call them out on the breach when it occurs, because the more time that passes between the time a breach occurs and the time you call them out on the breach, then the more time they can make an argument, right, that breach has been forgiven. So if there's a breach of contract and we're all just walking down the street towards closing like everything's okay, and I want to go back 2 weeks ago and say, 2 weeks ago you didn't deliver the earnest money, that was a material breach, I don't have to perform on the contract now. But for the last 2 weeks, all we've been doing is marching towards closing. It's a harder argument to make, you guys, right? So you got to call people out on the breaches when they occur, which means that you have to stay on top of it, buyers and sellers, brokers, right? You guys have to stay on top of that stuff. So, listing brokers have to stay on top of making sure that the earnest money gets over there. Because 2 weeks or 3 weeks into the contract, you find out they never delivered the earnest money, that's gonna be a hard argument to make. I'm not saying impossible, and I'm not giving you legal advice, but I'm telling you it makes it harder to make that argument, right? Same is true with the appraisal date. So anyway, the appraisal date is gone now, guys. In the event that they can't close because they don't order the appraisal timely, that is a breach of contract, right? That's a big breach of contract. So it's not like the seller doesn't have recourse, right? It's just they might not have recourse for a couple more weeks from this time frame. But that's gone. Paragraph 12 in the tax deferred exchange, it says, notwithstanding any other provision of this agreement, in the event of a 1031 exchange, this agreement shall be assignable to a qualified intermediary. We added that language because that's the way 1031 exchanges work, and as you guys know, we have a separate paragraph dealing with assignment of the contract. So if you wrote, no, it can't be assigned, but you said, yes, it is a 1031 exchange, then you've got a bit of a conflict, right? So we've said notwithstanding. Notwithstanding means ignore everything else in the contract. This is what prevails in the event that you're doing a 1031. They can assign it for purposes of the 1031, no matter what you've said other places in the contract, okay? Paragraph 14 is now assessments. Paragraph 15 is now the examination of title. This is where I told you we had to reformat some of the paragraph numbers so we didn't have grids like, ending at one page and starting on the next page. The paragraphs didn't change substantially. They were moved around for formatting reasons. We reformatted the disclosure and document section. That looks differently now. So before we had a lot of less than no questions in the document section. Lead-based paint, yes or no? Was the property built before 1978? Yes or no? Is it in a PID? Yes or no? Yes or no? Yes or no? So if you look at that section now, it looks very different. What it does is it has check boxes. The first thing you see in that section is check boxes under each of those individual things, and it says check if they apply. So, if lead-based paint applies, you check that. If PIDs apply, it checks that. You guys, I don't know what to say about not checking boxes you're supposed to be checking, right? I know it's frustrating when you, as a listing broker, get something and there's a blank in there and you know there's supposed to be something in there, right? And then you're forced to be countering on things that should have been completed by the buyer's broker, and that's a frustrating situation. You can assume, because this is what it means, that if a box is not checked, then it does not apply. And of course, if it does apply, right, you get an offer and it says, no, lead-based paint doesn't apply, the box is not checked, it's the same as them saying, no, it doesn't apply. And if that's not true, then you're going to have to counter. I can't help you with that. But if it's not checked because it really doesn't apply, for example, the PID box isn't checked because the PIDs don't apply, that's what it means, guys. It means it doesn't apply, okay? We had this conversation the other day at the Forms Committee meeting on an issue about, I'd like to see yes or no. I'd like for them to affirmatively answer that question, yes or no. And in some cases, that might be beneficial, but you guys need to remember that the fact that it's not checked means it's not applicable. And if that's the case, great. If it's not, then you're going to have to clean that up in a counteroffer. So that alone ended up freeing up about a quarter of a page, just being able to reformat that section. Yeah. Yeah, so, and it's cleaner. It's just much cleaner, I think, now. So paragraph 20G, we added 2 new paragraphs to the document section, tenants occupying property after closing. So interestingly enough, we created a tenant estoppel certificate a number of years ago, but I don't think many people are using it because you probably didn't even know it was in our library because we didn't make reference to it anywhere in the purchase agreement. So what are tenant estoppel certificates? These are, this is what it looks like, guys. See I've got A, B, C, and D with all of the stuff boxes. Very clean. Yeah, exactly. Very clean. So, and it still references the NMAR forms that are applicable, but it takes up a lot less room, and like I said, I think it's a lot cleaner. The tenant estoppel certificate is a form that the seller agrees, back in this paragraph, of the paragraph on documents, and if the buyer's filling it out, then they're going to probably say, yeah, I want a tenant estoppel certificate. And if the seller's still willing to provide that, then they will obviously not counter on that point. But what is a tenant certificate, a estoppel certificate? You're trying to get, if you're buying a property where tenants are going to remain in the property after closing, you're trying to get an assessment of that arrangement between the owner and the tenant from the tenant's perspective, right? You want to know what the tenant thinks is going on as far as leases and as far as promises to do certain things, repairs that have to be made. You want their perspective. They're living in the property. You want to know if the owner has promised to do anything for them that now your buyer is going to be responsible for doing for them, right? If there are any lease agreements that your seller has not disclosed to you or any agreements outside of the lease agreement that hasn't been disclosed. This is what the tenant estoppel certificate solicits from the tenant. So if you're a buyer's broker, you're going to be asking for this in your offer, right? Because you'd love to get those. If the seller for some reason can't provide those, then they're going to be countering and saying, no, I'm not going to provide those. But this is what the form looks like. It's a 2-page form, and it just asks a whole lot of questions about the property, because the tenant's living in the property, they know stuff about the property, and about the agreement they have with the owner, okay? So in our new document section, we have a section on tenants occupying the property. We do also address in that section what's going to happen with security deposits. Typically, those are credited to the buyer at closing, right? Because the seller's holding money that doesn't belong to the seller. Well, it may belong to the seller, but not until the tenant moves out, and only if there's damage to the property. So those are being credited to the buyer, so the buyer can distribute those accordingly at the time that the tenant leaves the property. So that language has been added, and then there is a box for you to check in that section whether or not, you can see this here, whether or not the tenant estoppel certificates will be provided. Okay. So the other form that we've referenced in the document section is our solar panel document 5125. And 5125 deals with assumptions on leases and loans. So in the event that the buyer is going to be assuming a lease or a loan for the solar panels that are on the property, then 5125 should be attached. And we've added that to the document section. And then we created kind of a division in the grid for manufactured housing. You'll see the solar panels at the bottom there. And then also in the, and this is our solar panel contingency form, guys, 5125. And again, it's for the assumption of leases and loans. Someone said to me the other day, well, what if they're planning on paying it off? There's no form for that. We have that covered in our title paragraph, guys. It says that the seller is responsible for satisfying all liens against a property. So if the solar panel company has filed a lien because there's solar panels on there, but the intent is to have that paid off, that falls under that paragraph of our purchase agreement already. There is some power purchase agreements, which is another way of purchasing solar panels that I'm going to be adding to the solar panel addendum, and that's on the agenda to work on this year, so I'm going to get that done, and that'll be incorporated into this 5125. In the grid, I will just make note that it does still have solar panel documents in there, and it says that if you're attaching 5125, then you don't need to complete that section, because 5125 has its own deadlines on there about production of documents, but remember, it only deals with leases and loans, right? So in the event that it is going to be paid off, but you still want to see those solar panel documents, right? You're not going to attach 5125, you're going to address it in the grid, you're not going to need to attach the additional form, okay? So remember, that's only for leases and loan assumptions. Paragraph 21, buyer's investigation of the surrounding area. So I changed the name of this to kind of bring home what this paragraph does, right? So it's been retitled to bring attention to the fact the buyer is to investigate the surrounding area before they go under contract, okay? Before they go under contract. That is the intent. That has not changed. That language has been in there for a number of years. But it's important that they understand that that's the case. And it was, I think I've told you guys this before, when we put that language in there, because we talked about, do we want them to be able to terminate the agreement if they find out that, there's some, big development going on in nearby that they don't like the idea of, or a highway or a roadway, or what if they find out that there's a sexual predator that lives in the I shouldn't say predator, that's too SVU, isn't it? Yeah, I watch too much SVU. But, somebody on the sex offender registry, right, who lives down the street. What do we do in that scenario? It's interesting, and I know I repeat myself to those of you, and I think I've talked to the same group, so I should really get some new material. But in our Non-Disclosure Act here in New Mexico, we don't have to disclose the fact that a property is the location of a homicide, suicide, natural death, someone lived there who had HIV or AIDS, the place where a felony was committed. We don't have to disclose those things. Arizona has the same exact law, only in theirs they additionally have, only one additional thing in addition to ours, sex offenders. So they have in their statute that is not a required disclosure on the behalf of the seller, and it doesn't provide an out, right to terminate for the buyer. And I told Steve, I said, I want that in our statute. Can we get that in our statute? Because, not because I'm all into not disclosing, sexual offenders in the neighborhood, but because there's clarity, right? And from my perspective, I want clarity in the law so that when you call me, I don't have to give you all the arguments on both sides of things. I can just tell you that the law says you don't have to disclose that. So Steve said, well, how did they get that in there? I mean, how do you go to the legislature and say, we don't want sellers to have to disclose that there are sexual offenders on the registry living in the nearby area? And so I asked the Arizona attorney how they did that, and they really just deferred to the fact that there is a public-facing website available for that information, and to put sellers and listing brokers in a spot where they have to maybe possibly be even defaming someone, right, by making comments that aren't necessarily true, when the public can, anybody can go to the registry if that's important to them and find out the information. So there was a case over in Arizona where there was non-disclosure of a predator in the, or a something on the sexual registry. And the buyer brought suit against the seller and the listing broker after closing, and they won that lawsuit. The seller and the listing broker won that lawsuit because they relied on the statute, they relied on language in the contract, they relied on language in the seller disclosure, and they prevailed. So that's great news, and I love that kind of clarity in the law. So I would still like to get that on there if at all possible, but Steve doesn't seem to think it's really all that important. But it's really important to me because, again, I have to answer that question on a regular basis for you guys. But this is where, when we're thinking about putting this language in the contract, we're trying to figure out where to put it in the contract, put it at the beginning, put it at the end. Where do we put this language that it is responsibility of the buyer to look around the area before they enter into the contract? And everybody, like I said, I've said this before, we were going to put it at the beginning, and everyone thought, well, that's not a very nice way to begin the conversation or write an offer. That's kind of negative. And then we talked about, well, let's put it at the very end before they sign. They can read it just before they sign. And everybody said, well, now we've filled out the entire purchase agreement, and they realize they haven't looked at the neighborhood, and we can't do anything. We have to put a stop to everything. Let's not put it there. And so with all of this debate back and forth, they decided to stick it right in the middle of the paragraph where nobody reads it, right? And nobody even looks at it. So I know how much you guys love buyer signatures in the middle of the purchase agreement, in the middle of a page. I know you love that. So that's where I have added buyer's initials in the middle of the page here, because I'm afraid this is being passed over on a regular basis, and I'm afraid of that because I get the phone calls, guys. My buyer wants out because they found out this is happening down the street. They found out there is a sexual somebody on the sexual registry down the street. They found out this is happening around the corner, and I point them back to that paragraph. But again, I've said this before too, that electronic signatures are so wonderful and so terrible at the same time, right? Because nobody's reading anything, right? And all they do is click, click, click through the contract, and they sign it, and they, nothing's important until it's important, right? So I do want to make some attempt to bring the buyer's attention to this particular paragraph, because that is what they're saying here. They are warranting that they have looked around the neighborhood and they have done these things. So we have added that. We did also add in this paragraph on the fact that what this means when you say you've warranted this before you go under contract means that it does not provide you a right to terminate based on these things. Now, this is a little tricky with the way we're approaching inspections now, right? Which we're going to talk about in a minute. But the way we approach inspections now is you don't have to provide a copy of the report in the event that you're terminating the contract. So are they basing it on the inspection report when they terminate, or are they basing it on the fact that they found out there was a sexual predator living in the area, or someone on the sex registry, or the new development that's going around the corner? Will we ever know for sure? We will never know for sure, guys. But at least we're trying to bring this to their attention so they maybe take a pause, right? Say, wait a second, I do want to look at the sexual registry before I sign this contract, right? And that way you'll avoid a termination based on that particular issue. Paragraph 23 is our inspection paragraph, this paragraph, it just, this is just an ongoing thing. I don't think we're ever going to, this is the number one thing in any transaction, is the whole way inspections are handled. I mean, it creates the most angst between the parties, the most terminations of the contracts. It is just, and it just generates the most number of questions. I could probably write 10 pages in this person, all about just the various ways to handle this this whole inspection objections process. But I've not done that. I did get rid of a page, and we have clarified it a little bit. So in paragraph 23, the inspections, the heading, it requires buyers to instruct their inspectors not to send inspection reports to seller unless directed to do so by seller in writing. As you guys know, we have changed the way we do this, right? So upon termination, there is not a requirement anymore to produce an inspection report with the termination. And the reason we did that was a couple-fold. One of the things, what reasons we did it, is because sellers think they want inspections, but they don't necessarily want inspections. Because it does not matter, again, what kind of idiot you think the inspector is, they're stuck with that inspection report and that bad information in the inspection report that they have to share with the next buyer if this deal terminates, right? So they think they want the inspection reports, but maybe they don't want it. But the main reason, and that's always been the case, I know I've told you about my friend Oliver. He was a Colorado attorney, a wonderful attorney, and he used to do this circuit and had this great handlebar mustache, and he was very entertaining. And he used to always tell sellers, you do not want a copy of that inspection report, right? But we were making them provide it, the buyers provided, the way our contract worked. And that was always a discussion we had in the Fourth Committee meeting. And the counter argument to that was, from a buyer's perspective, we need to know that, or from the seller's perspective, we need to know the buyer's terminating in good faith, right? Again, they didn't just roll over in bed the next morning and decide they don't want to buy a property, and somehow providing that inspection report made us feel warm and fuzzy about the termination. So we required it, but we stopped requiring it because we did recognize the problem with that from the seller's perspective. But the other main reason we did is because of copyright language that the inspectors are putting in the reports, right? That says you can't share this report with anybody. You can't just redistribute it. You can't do all these things because it violates my copyright. We haven't had that case litigated here in New Mexico. I don't know if that would be successful or not, but I do know that some inspectors felt so strongly about it that they were threatening lawsuits against buyer brokers for sharing it with listing brokers from sharing it with the next buyer that came along. A listing broker uploaded it into the MLS, and the MLS got threatened with a lawsuit if they didn't get it out of the MLS immediately. So we're having this issue, and for those of you who attended the forum, which I think, I know Bev was there, I don't know who else was there, the inspector forum where we all met with the home inspectors to talk about the home inspector licensing law that's now in effect, but not really. Yeah, just a side note on that, as you know, we got that law passed, right? So as of January 1st of this year, they have to be licensed as home inspectors. But I say not really because they just barely got the board together. And they haven't got any of the regulations in place yet, and they haven't gotten anything, so nothing's happening. For those of you who were here yesterday, I talked about it a bit at my legal update. So that's not really happening yet, but nonetheless, it is the intention. But anyway, that forum that we did, we spent half the time there that we were supposed to be talking about home inspector licensing, talking about our copyright, their copyright, and the way you guys are treating their inspection reports. And we had they ran the gamut. Some of the inspectors were like, share it with anybody, I don't care. And then others were just adamant it was their report and it should be shared with nobody, right? So when we were having all this trouble with copyright language, the brokers were asking me, Ashely, can't you fix this? Just call the inspectors and tell them that they can't put this language in there. And I appreciate the kind of power you guys think I wield. But unfortunately, I don't have that kind of power. So I can't fix all of the home inspectors' contracts out there. But I can tell you that, that we are making an effort to address that through our contract, which we can control. So we talked about the rationale. The other issue is that if they are objecting to something, they don't have to create a report or produce the report for the entire report for their objection. They only have to produce the report for the specific section that they are objecting to. Okay, so that's it's very clear in there now that that's the case. Paragraph 23E, which is our delivery deadline. The language in 23E used to be actually further down in that paragraph. I moved it up under the delivery deadline. It didn't change at all, but now all of the language pertaining to delivery deadline is now up in 23E. In the 23G, which is our objections, resolution, and termination paragraph, now the entire section was reworded and reformatted. Again, I'm telling you guys, you need to have, the way it's written now is that a seller can, in writing, request the entire inspection report. They can, by giving written direction to the buyer, they can get the whole inspection report in the event of termination or in the event of objection. You guys, as listing brokers, need to be having substantive conversations with your sellers about why they would not want the report. If they ultimately, sometimes you get sellers that are just stubborn, right? And they just want a copy of the report. They don't care that they're going to have to share all that bad information with the next buyer. They don't care that you've got copyright issues, which means you're not going to be able to provide the whole report. You're going to have to go back to your property disclosure statement and update that with all of the ugly information. They still want a copy of it. And so the way the contract actually works now is arguably what they would have had to do is they would have had to counter it and say, you're going to provide me with a report, because our contract says that no reports are going to go over to the other side. But they'd have to counter and say, I want a copy of the report. We've kind of freed that up a little bit to say all they have to do is provide written notification that they want a report. So they don't have to get an agreement by the buyer. They just have to be able to provide written notification. So you guys on the listing side are having really good conversations with your sellers before they make that decision, but if ultimately that's what they want, it's not a matter of getting a counteroffer in place or an amendment in place, they can just put it in writing that that's what they want. And who's gonna put it in writing? You or them? They are. They're gonna put it in writing, and you're gonna forward it to the other side and say, I want a copy of the report. And per the contract now, they have to provide it, okay? But again, be careful what you ask for, seller, right? Be careful. So this is all the delivery deadline in paragraph 23 that was already in there that we moved up, talking about how the delivery deadline only applies if the seller is responsible for delivering the reported document to the buyer. It doesn't apply if the buyer's ordering it out. We'd already added that in there last time we released it. So again, in the event that the seller is providing them a document, this delivery to the buyer, this delivery deadline applies. But if the buyer is getting the document or report from the inspector, for example, they've contracted with, this has nothing to do with when their inspector has to provide them with the report. Okay, so that's clarified here. If seller is responsible for ordering an inspection document and does not receive the report document by the delivery deadline, the parties may agree to extend, or buyer may elect to terminate the agreement and receive a refund of the earnest money. This is all regular language that's been in there. It's just been moved up to the delivery deadline section because that's where it needs to go. In the objections, resolution, termination paragraph, we talk about delivering, we kind of break it down into two sections now. We talk about what's required in the event of termination and what's required in the event of objection. So again, termination, no report. In event of objection, just the copy, the section of the report. And we talk about now, even further breaking it down, that if you're talking about surveys or you're talking about documents, we want a copy of the entire report, the entire document, the entire survey. But if you're talking about inspections, then we're only looking for the portion of the survey. We're not dealing with copyright language in that other context, guys. With surveys, we're not having surveyors try to sue us because we're sharing surveys, right? So that's a non-issue. So, if it's a document or it's a survey, you can produce the whole thing. But if it's the inspection report, which is where we have these issues, then we're only doing the section of the report, okay? And that's broken down here into inspections and into documents or surveys now. We now have a section called seller's response to objections that it kind of explains what you guys can do the seller can do in the event. And again, this isn't new language. We just kind of retitled it seller's response. Cure objections is requested, provide an alternative cure or refuse to cure. This is important, again, for you listing brokers to be having this conversation with your seller because this comes up quite frequently. If the seller refuses to do everything the buyer has asked them to do in the manner that they asked them to do it, then when that comes back over to the buyer, they can terminate. In the previous paragraph, we say that in the event that a buyer, because you got to remember, guys, buyers are standing at a crossroads and they're making a determination. I'm going to terminate or I'm going to object, right? And what was happening before we were trying to clarify this was language is they would choose not to terminate by the objection deadline. They decided to ask for something, the seller to cure something. Then they would send their request out to the seller to cure something, and what would happen before the seller even had a chance to respond? They'd try to terminate the contract. They wouldn't even wait for the seller to respond, but they had an opportunity to terminate at the objection deadline, and they passed that, right? So you don't get two bites at the apple, guys. If you've decided to walk down that path and you've asked for them to cure something, you've got to give them an opportunity to respond to that. All right, it's only fair because otherwise you're getting two bites at that termination apple, right? So they have to wait till it comes back, and we tell them that now in this paragraph. It's very clear. You have to wait. You cannot terminate before they get back with you. But sellers, because this happens all the time too, guys. All of you all think the forms are too long. You need to come and work with me on the hotline for 1 week. And I don't know if you guys, I'm sure you guys are on the board, but I do a board report every time we have a board meeting. I go through during a quarter, probably around somewhere between 11 and 1,400 calls in emails. Is what I feel during the quarter. I've been doing that for 13 years. There are very few things you guys can ask me I don't have an answer to. When I started this job, every question was so laborious, and I had done real estate law before this, but it was so hard. I'm like, I don't know. I go research it for 4 hours and come back. Can you imagine what my life was like in the beginning? It was so hard. I don't know how to. I wish that when I leave this position, I could just somehow transfer all of this. And I don't even know where to go with this knowledge, right? I mean, this is all I can do with the knowledge I have in my head now. But it was just painful. It was absolutely painful. But now after doing this for 13 years, about 1,300 calls and emails every quarter, I can tell you I can answer most of your questions off the top of my head. But if you run the hotline for any period of time, you realize the kind of stuff that comes up in your daily stuff, right? You know your stuff. Just multiply that by 6,700 people in our state, right? And imagine the kind of stuff that comes up. So what was happening, of course, is that the seller was responding, and they weren't giving them everything they wanted, right? And then the buyer was terminating, and the seller was doing what? Wait a second. No, I'll do it. I'll do everything you asked for. Everything the way you want me to do it, right? I mean, they were like backtracking as fast as they could backtrack. I'll do everything you asked me to do, right? And then I get the call. Well, can they do that? Now the seller is willing to do everything, and the buyer's trying to terminate. What, I don't know. I mean, I can't tell you definitively how that would play out, but I can put some language in the contract to address that. And that's what I've done. Right, so now we're very clear that in the event that the seller doesn't agree to do everything the buyer's asked to do, exactly how the buyer's asked to do it, then it does put the ball back in the buyer's court to say, okay, I'm done. So you have to be having that conversation with your seller, making sure that they understand when they say, no, I'm not going to do it all. And well, let's just go back and say we're going to do a few things and see what they did. Well, they might just terminate the contract, right? And now we're very clear that that's the right thing they have to do, right? They can do that, right? So very important. I moved the repair completion deadline, and it's nothing new, but we moved it up because it's back in the inspections, objections, resolution section, opposed to down below the termination. And the resolution, and also the other thing that we put in here, guys, and it's actually, here we go, on the very last sentence, which of the resolution. At any point, if the buyer wants to pull all of their objections off the table, as long as they do so by the resolution deadline, that constitutes resolution. So they're negotiating and negotiating, you're coming up on a resolution deadline. What happens to the contract when you get to the resolution deadline and there's no resolution? It's over. It terminates automatically, right? And we do define what resolution is. It's like, well, what does that mean? I mean, what is resolution? We have a definition of that. So it's a written agreement between the parties as to how to resolve the buyer's objections, right? If you don't get that by the resolution deadline, you have an automatic termination of the contract. Now, again, if you guys all just keep walking down the path and negotiating the contract past the resolution deadline, it's going to be hard to argue that it automatically terminated. But assuming that that's not the case, you may have a buyer who ultimately wants that property even if they can't get all those things done. And so at the very last minute, they are willing to say, fine, I'll just pull it off the table. Now, the conversation we had the other day, which we will continue to discuss at the Forms Committee, but we didn't come to any changes at this point, was whether or not, can you go back to a previous seller offer, right? So we know when we're countering offers, right? If you counter an offer, then you can't go back and accept a previous offer, right? That's off the table at that point. But in the context of the inspections, do we want them to be able to go back and grab another offer? So you're going back and forth, and you're getting ready to the resolution deadline. There's no resolution. You want to pull everything off, but the seller had offered to do a couple of things in that negotiation process. Can I go back and grab those couple of things, or do I have to just say I'm done with I'm pulling everything off the table? So right now, the way the contract works is you got to pull everything off the table to keep it from terminating. We're going to have further discussion at the Forms Committee meeting about whether or not we want to create some language in there that allows them to pull some previous offer that the seller has made. That's more complicated than it sounds, you guys, right? Because there's a lot of negotiation. So at this point, we're not going there, and I don't know if we ever will. But they can keep it from terminating by pulling everything off the table by the resolution deadline. And as I've told you guys before, your buyers should be doing this. Not you, your buyers, right? So get amendments to your RWs, get some written, something, even if you can't get in something signed, just get something from your buyer in an ideal world before to the other side that says, okay, I pull everything off the table, I have no objections. That constitutes resolution, right? And we're very clear about that in the contract, all right? So that whole section has been reworked. In the termination provision, we just make it clear that you don't have to send a copy, and you will not send a copy of the document survey or anything else if you're just terminating unless the seller requested in writing, and the seller can request it in writing. Paragraph 29, the pre-closing walkthrough. The only thing I added to that was notwithstanding the foregoing, if the property is not in the same condition as the date of acceptance due to fire or other casualty, we're referencing the risk of loss paragraph, okay? Because that could happen during a walkthrough, right? The risk of loss paragraph has been completely reworked. Do I have that here? Yeah. You guys, you have no idea what this paragraph said before, do you? It was so frightening for a buyer. Absolutely frightening for a buyer. I mean, I would be amending this every single time. I'd be sending an amendment over with my offer going, you gotta be kidding me, right? Because what it said before, that in the event there was fire or casualty, the buyer had 3 days to decide if they wanted to move forward with the deal. And if they failed to notify the seller in 3 days, they were going to closing. And if there was insurance and they could have get an assignment of the proceeds, they were gonna get them. But if there was no insurance, they were getting nothing and they were going to closing. 3 days. So I have like 3 calls last month alone on this particular paragraph. Yeah, and there was a fire, other casualty occurred, and the listing brokers or the buyer's brokers thinking, well, you know, we have a provision in the contract. This is the property has to look the same as it did when we went under contract, and it doesn't, right? Because there was a fire, because the tree fell on it, because whatever the case may be. And I said, but that's not the paragraph that applies here. You have a paragraph that specifically applies to risk of loss type situations. That is true in the event that there's no risk of loss, right? That's not a situation of risk of loss. The property does have to look like it did when it went under contract, normal wear and tear accepted. But if you have a fire or other casualty, the risk of loss paragraph comes into play. And I said, so when did this happen? Oh, about 10 days ago. Well, according to the contract, your client's going to closing, and in at least one of those situations, there was no insurance. So you're accepting that property in its current condition because that's what that paragraph says. Right? And I've read it before and I just read it through, but as I was getting these calls and I'm looking at it, I'm going, you've got to be kidding me, right? I mean, that's really not fair for a buyer to have to make that decision. They don't even know if there's insurance money available. So I reworked this paragraph. Is it perfect? No, nothing in this purchase agreement is perfect. But it does give the buyer a much better position. So within 3 days of the loss, the seller has to notify them that there's been this loss based on casualty or fire, right? And after they get this notification, the buyer may terminate the agreement and receive a refund of all earnest money, or buyer may elect to delay his decision until he receives written notification from the seller of the amount of insurance proceeds available. Don't you want to know if there's any money available to fix the problem before you make a determination as to whether or not you're going to terminate? Because if you can get the insurance money, you might just go to closing and fix the problem after the fact, and you're fine with that. But how can you make that decision without knowing if there's insurance, right? So if you opt to hang in there a little bit longer and wait for that insurance notification, then any of the buyer elects to receive the insurance notification, seller shall work diligently with the insurance company to determine the amount of coverage, and buyer shall have 3 days from receipt of the insurance notification to terminate the agreement because there's inadequate insurance, or they don't want to mess with it, or to close and receive an assignment of the seller's portion of the insurance proceeds. Now, you do need to note, you guys, that in any event that the buyer does nothing, that they miss all these, we've given them opportunities, right? So if they miss all of these, then it's going to be assumed that they're going to go to closing just like it was before, and they're going to get an assignment of proceeds if there are any to be assigned, okay? So they have multiple opportunities here. It's really been cleaned up to help the buyer, but they still have to do something, and if they don't, there will be assumptions made, okay? So very important on that. You guys remember that that's very different than the same condition as it was in when it went under contract. So this was in there, guys, but I put exclamation points in triangles. And that means it's really super important, you guys, all right? So if I could do this in color, I would make this bright yellow or something. But anyway, so we have this wire fraud alert language that we've had in there before, but we're kind of bringing more attention to it. And then the other thing that we've added is this attention to buyers and sellers. And this has changed just a tiny bit because it was at the end of 14 out of 15 pages. But at the Forms Committee meeting the other day, we opted to take off the buyer and seller's contact information from the signature pages because there's no reason for it to be there, right? So we need their names, we need their signatures, but we don't need to know where they live, we don't need to know phone numbers. And some people are contacting sellers directly, buyers are, so we've taken that off of there, so that frees up a little more room. What I'm going to do, I'm probably going to try to move one or both these boxes so it's coming right above the signature. Because as it is now, the signature page takes up the whole page and I have no room to put anything else there, so it's at the bottom of this 14 to 15. But once I take some of that off, I'll be able to move one of these boxes right above the signature line, which might bring more attention to it. But that box that we've added, or no, I guess it wasn't added, we determined, right, Beth? That was in there, the attention, that last box? Okay, that the obligations and responsibilities set forth in the purchase agreement are those of the parties and not of the brokers.
The seller's initials weren't on the wire.
The what?
The seller's initials were not on the wire.
Yeah, right, yeah. And we added seller's initials on the wire. Yeah, because we know how much you like Excel. And you know, I guess we leave those, I don't know, maybe I can take a poll, because if I end up, that one will be at the bottom of the page, the very bottom of the page. I think the only one I'm gonna be able to move over is probably the attention to buyers. But you know, the wire fraud, we've gone back and forth about creating a separate document for that. It's happening, guys. People here in our state, have anybody in this room gotten in trouble with that? I mean, in the sense that it's happened. Yeah, in the sense that, yeah. So it happens, guys. It's been happening throughout the state. So no matter how much, you know, we just really need to bring this to the attention of the buyers and sellers if they're bringing money to closing. Yeah. No questions to the end, Danny. No, I'm kidding. I know you can ask a question.
I just wanted to point out.
Yeah.
On the signature page.
Yeah.
We also voted on somebody to add a third.
Third line, yes, thank you, Danny. Thank you, thank you. So we voted also to add a third buyer line and a third seller line if we have the room there, and I think we will, even with this little box if we move it over there. So we have room for 3 signatures on the buyer side, 3 signatures on the seller side. Yeah, yeah. Thank you, Danny. I'm giving you a hard time. Thank you. Poor Danny. I know. Thank you, Danny. Yeah.
On the signature page.
Yeah,
We also voted, Forms Committee to add the third.
third line, yes, thank you, Danny, thank you. So we voted also to add a third buyer line and a third seller line, if we have the room there, and I think we will, even with this little box if we move it over there. So we have room for 3 signatures on the buyer side, 3 signatures on the seller side, yeah, thank you, Danny.